SJC-08464, Commonwealth versus Charles Robinson.
Mr. Krasky, good morning.
Good morning, Your Honors. Chief Justice, honorable members of the panel. This has been may I proceed?
Yes, please.
Thank you. As you can see from the chronology in this case, it's been a pretty long journey, and I think we still have a ways to go because parallel to this, there's still the motion that Judge Botsford was aware of that is still pending out there, given the mental health issues surrounding Mr. Robinson. And this case actually started...
And do we know, I know it's not to be decided here, because
No.
and I know we've reserved your rights with regard to it, but do we know what the issues that are to be raised in that motion are?
This is the reason we've come this far down the road. The issue is, would Mr. Robinson be competent enough to sit in on a hearing on whether or not he was competent at the time of the trial?
So it's okay.
Early on in this case, we had...
The issue is a competency issue.
Correct.
That is, okay, which is not among the issues that we are addressing.
No, not at this time.
I wasn't sure what the nature of the issue.
But it's a double competency issue, which is kind of complicated.
Okay,
All right.
well, let's focus on this, but it appears that this is quite separate and distinct from all the arguments you're making today.
So Judge Botsford, I think last May, held my feet to the fire and said, do the direct appeal, so here we are. And as I was looking, I had read the transcript over the years, but mainly my concern was Mr. Robinson's mental health, which is an issue that will be resolved at some point. But basically, going through the transcript and the brief I submit, this case started in February of 2000. Mr. Figueroa was shot to death on February 24th of 2000. February 25th, with very little investigation, Mr. Robinson was arrested. He was arraigned in the Superior Court in Barnstable County on May 2nd of 2000, and on a first-degree murder case with 25 witnesses, he went to trial on August 14th. I've seen trespass cases held in the district court longer than that. In any event, when I looked at the direct appeal, and I had done that over the years, it was tried in 2000. At that point, the Salemi case was on the books. It was the law of the land. The Mazza case had been tried in a decision, and I think Salemi was 87 and Mazza was 85. So Salemi and Mazza were the circumstantial required finding cases. Going through the trial transcript, and I'm not going into ineffective at this point, but it's important that I emphasize it because there was a required finding motion filed, and it was argued. In the attorney's argument on the required finding, and this is similar to the Commonwealth's brief, there was no reference, no citation to Salemi and Mazza. And on the facts of these cases, there are other issues, but the insufficiency of the evidence, I suggest, would lead a presiding judge to believe that there was no way that this case should have gone to a jury. There was absolutely zero forensic evidence. The closest the government could get to any kind of inculpatory statement from Mr. Robinson, and I suggest it was almost catastrophic the way the attorney handled it. There was a statement to the effect that in March 24th of 2000, that Mr. Robinson and a Mr. Garcia got in an altercation at the Barnstable House of Correction. And the government proffered as evidence that Mr. Robinson said to Mr. Garcia, I'm going to kill you, something to that effect, and Mr. Garcia, in a quasi-semi-maximum security facility, said, you don't have a gun. Preposterous statement to have been offered, and it was really mishandled, I suggest, by the attorney, but I'm putting this on as part of this factual basis. And the jury was asked to believe that Mr. Robinson replied. That's what the other fellow thought, too.
Now, didn't another inmate also testify that he had heard that?
That's correct. But the principal, Mr. Garcia, never said that he said Mr. Figueroa. what happened here, and I think without going into ineffective, the court can make its own decision on how preposterous this proposition was by the government. They're in a new facility. I think Barnstable was a new facility at the time. There are corrections officers. You're subject to strip search. You're in a semi-quasi-maximum security facility. And the first thing out of somebody's mouth is when they think they're going to be attacked by another inmate, is they're going to be shot. It was absurd. And the fact that somebody would respond by saying, well, that's what the other fellow thought too, as if in the middle of a jail you had access to a gun.
Without me commenting on whether it's absurd or not absurd.
Right.
How would that not be an issue for the jury?
Well,
I mean, there may be ineffective assistance to counsel claims that you're sort of alluding to right here that we're not going to discuss today. But even, let's take your view of the weight of the evidence. Just take your view of the weight of the evidence. Why doesn't that go into the calibration of whether or not the burden of production's been satisfied?
oh, it could, but the strategy, I suggest, was not well taken, because what the attorney did, now, this case is only at the trial time, maybe 110, 120 days old. There are 25 witnesses. I don't think it was a well-thought-out defense. So what happens is, somehow, not going after the forensic evidence, the attorney decides, well, I'll put on the 5 inmates who were around that day and get them on the stand to say it never happened. Well, all that did, after the first one, you should have realized that the experienced district attorney was going to put his size 9 shoe to the witnesses and kick them all over the stand. And what that did was give an organic life to that statement. That statement, I think, probably would have been flayed in about 2 minutes of cross-examination, pointing out the preposterousness. You take that statement out, and there's absolutely not a scintilla of evidence. And even that statement, I think, is so thin on the credibility that if you go to Salemi and Mazza and you're looking for motive, you're looking for for opportunity, that doesn't even fit into the mold. Salemi and Mazza were, on the facts, even more inculpatory than this. Frank Salemi is sitting next to the decedent 10 minutes before the decedent in the Salemi case is shot. And Mazza, it's at the old Howard Johnson's on the expressway. Mazza leaves the car at the gas station with his friend, goes to where the body was found eventually, and comes back. So within minutes, there is a connection between Mazza and Salemi. In this case, Mr. Robinson isn't seen since 9 o'clock in the evening. The shooting takes place around 10:15 in the evening. And the government is asserting as fact the allegation that Mr. Robinson was the last one to see Mr. Figueroa. Not true, Your Honors, because there are a number of fingerprints that weren't examined. In fact, there was a Mr. Ferguson who was there who was involved with Mr. Robinson and Mr. Figueroa. His fingerprints were never implicated by any examination by a fingerprint expert. Letitia Rose had testified that there were a number of people who were in and out buying marijuana, I believe, from Mr. Figueroa. None of that was followed through, but of all of the forensic evidence that was not identified, Mr. Robinson, his car was examined, his clothing, which was the same clothing that he had on when Letitia Rose last saw him at 9 o'clock, had absolutely no forensic value. Because remember, if you look, there was a blood spatter expert who talked about the conical spatter, and it would have been like 2 to 3, 4 inches down. We've been through the blood spatter before. And in this case, there would have been at least occult blood and a transfer to Mr. Robinson's Lexus. And you're familiar with the Lexus. No transfer. And the evidence was that he was wearing black clothing. When he was seen in the morning he was arrested, black clothing. Black clothing was investigated forensically, no blood spatter, no occult blood, nothing. No gunshot residue. And remember, it's pretty clear that Mr. Ferguson, and I'm not going into the third party, I'm talking specifically, but I want to remind the court that Mr. Ferguson was on the run. He took off. And he was never investigated for gunshot residue, forensics. And I suggest when the only thing that they have is an hour or so later is that some cell tower information put Mr. Robinson in the Marion Mattapoisett area. And they had some officers, state police troopers go from Falmouth to Marion, and that was the time. So what? Why wasn't it attacked? So what? Because there was a whole hour where they don't know who went where. This person could have been at IHOP or someplace. So they're speculating that at some point that Mr. Robinson was in that apartment and he did something with to
Can I ask
Mr.
you-
Figueroa.
I just was wondering whether you're saying that these things weren't argued at trial?
No, they weren't argued.
None of this was argued at
Well,
trial?
the third-party culprit was argued. It wasn't, I was going to say it wasn't very robustly argued. It wasn't, I mean, this is not the point of this thing, but the transcript pretty much speaks for itself of the representation that Mr. Robinson got on the Salemi and Mazza issue. Go to the required finding. I don't mean to skip around here, but I've got just a short time, and there are a lot of things that...
If I can make sure that I understand, Rose is at the apartment and
Correct.
with the victim. She leaves at 9.
Right.
When she leaves, is the defendant still there?
I believe so.
Okay, so when she leaves, she says, I left the victim alone with the defendant.
Right.
And then shots are fired at 10:15. And then we have the 11:29 CSLI putting him near Mattapoisett.
Right.
Is there any earlier CSLI, or is the first CSLI?
No, that's the first. And if this case was tried with any challenge to the CSLI, I will tell the court, it's in the paperwork, the CSLI was never gained by any kind of warrant. And we've had Augustine, Carpenter, Fabrique since those, and there was no challenge. In fact, all that was done was that a cell phone tower fellow expert was brought in to say, well, if there's too much traffic on one tower, it might go to another. But now
Was there an application under Section 2703 for the CSLI?
not that I could find in the paperwork that I had. In fact, I think, and my memory is that it was one of those old administrative summonses that T-Mobile and Metro PC would set up a little departments, supposedly having trained personnel, but all that meant was a police officer would say, I have an emergency, call T-Mobile, call Verizon, and they get those records. My memory, and I don't want to misspeak, but my memory is that it was a warrantless CSLI.
Okay, but you don't raise that in your brief.
No, I didn't raise that, but I just, as an aside, talking about the challenges on cross-examination, the challenges to the evidence into the case, because you've got to raise reasonable doubt in a first-degree murder case every way you can, and there was an attempt to raise reasonable doubt by challenging the traffic diversion on a cell, but there was no challenge to the cell phone, the CSLI evidence itself.
I don't know.
And that may be, the subject of something else, but
I don't know if the chief's done with this chronology. So, Ms. Cusk, can I turn to the jury issue?
pardon?
The juror issue?
Oh,
On-
yeah,
on-
yeah.
On juror 27? Let me just ask you a question. So, an issue is raised on day 3 about 27.
Juror
and-
27.
And then the prosecutor says, I think the juror should go. The defense attorney says, no, she should stay. He wants her. And then the judge ultimately says, I have a choice. We're running out of jurors, but I'm going to dismiss her, and I'll take my chances down the road.
Right.
So the issue that you raise is not the dismissal of the juror, but you raise the inquiry of the remaining jurors. But at trial, the defense attorneys basically took a contrary position and said it's not she should stay. What she says isn't a problem. Now we're arguing, or you're arguing, there's extraneous information based on her political, religious beliefs. It's extraneous. What do we make of the defense attorney's take on it on the ground at the time? There
There was no effort to ask the judge to find out if there was any kind of taint or pollution from those statements going through the jury pool, the deliberating jury, rather. And what happened is that he raised the issue. He asked for further instructions on 2.7 and 1.5, but what happened was the judge said, look, there are a lot of things that come to me, and I don't let you know. That's right on the record. That should have set the defense attorney's antennas kind of fluttering, because the judge now has information, and under Relsco and all of the jury misconduct cases, the inquiry is required. And as a matter of fact, I think it was aggravated by the judge, who was a real good judge. I knew Judge O'Neill. I think we all knew Judge O'Neill. He, in his gentlemanly way, told the jurors when there was some question about them discussing Juror 2.7 and Juror 1.5's information, that they shouldn't do it. It's not essential that they don't discuss, but that they shouldn't discuss it, which I suggest, and I said in my brief, then gave the jurors license to do something that they weren't supposed to do.
And when Juror 2.7 makes those remarks about basically those good-for-nothing people, she's saying it in context of the government's case, right? These are all the government's witnesses, the one with the neck tattoo and the like?
I think the way I believe it should be read is a pox on all their houses. If you're there, you're guilty. That's what I inferred from what she said. They're all bad, curse them all, and because Mr. Robinson is in that group, he's part of that ilk. Okay. So I don't even think it's a strategy to try to have kept that juror on. And I suggest that there should have been a more aggressive and robust effort by the defense counsel to tell the judge, to give the judge guidance. I mean, the judge is not infallible, so you have to give the judge guidance. He should have given him guidance on Mazda and Salemi. He should have given him guidance on Relsco in all of the juror taint cases.
And they were before us. We don't have the ineffective assistance. We may
no,
get
no,
one,
no. I'm just here, but
right.
You know, these can't be avoided. Because this is an experienced panel here. You see this all of the time.
Your argument is it's extraneous, so no matter what the defense attorney did, there should have been an inquiry to ferret out extraneous material.
I think the case law is pretty clear, and I cite Relsco from the Third Circuit, and there are other cases that, you know, I can't give you off the top of my head, but...
Could you tell me why the judge doing the voir dire of Juror 2.7 in the lobby and there being no objection, distinguish it from the public trial cases?
I saw that in the Commonwealth's brief, one of the captions. This is not a courtroom closure issue. The Cohen case was my case, so I had done courtroom closure cases. This had nothing to do with courtroom closure. This was jury deliberations. Courtroom closure comes before you even get to deliberation. Once you're at the deliberation point, it's a whole different standard. The jury has to be protected. The jury room is sacrosanct. And anything that happens in there has to be kept to the standards evinced by the judge in his instruction. There was no instruction. We don't know what the judge talked to the juror about because there was a transcript, but the judge also begs the question, what else was talked about when he said, I don't bring everything to your attention? Well, we're a defense counsel. We are entitled to everything that a juror says because, as I said, it's sacrosanct in there, but you can't go beyond the bounds of what the judge is supposed to instruct. If the judge doesn't instruct the jury, how does the jury know? And I suggest it was really dangerous for the judge that it's not essential.
So isn't it as basic as that when there's a voir dire in the lobby with a juror, there's absolutely no way to figure out if something happened that might create prejudice or a substantial likelihood of miscarriage of justice.
Err on the side.
As opposed to public trial where you have a transcript of everything that happened.
I thought it was recorded, though, and there was a readback.
Pardon?
I thought my memory is that the judge inquired, and this is obviously what happened in 2000.
2000.
But the judge inquired of the juror with the stenographer in his lobby. They come back out, and they do a readback of,
Right.
of what was said, correct? I think that's what happened, right?
But we don't have a comprehensive view that the defense lawyer would have had he asserted his right to be there.
Oh, absolutely, I don't quibble that, you know, that
But
the
he
defense
did-
attorney
he-
didn't have a chance to ask questions or judge the demeanor.
I believe, Your Honor, that it begged the question, was more going on other than that transcript? And I think the defense attorney did allude to that, and he was concerned
Well,
at
you
some
alluded
point when
to
the
it
light
too-
was...
You alluded to it too. You said that at some point the judge said that he's not saying everything that's going on.
That's,
That's
yes,
in we'll see that in the transcript.
right. So,
That's what you're saying though, right?
what
You're
I'm-
saying that the judge told the lawyers in reference to the discussions with at least Juror 27, if not Juror 15, that you don't know necessarily everything that's going on. I'm sorry, I thought you told us that the judge made a comment to the lawyers that the judge is not necessarily telling them everything that...
Yes, yes.
Did you tell us?
Yes, yes. I cite that in my brief. In fact, I put it in bold.
Okay.
Like essentially, you don't have to do what, you don't have to listen to me when I say, don't discuss it, essentially. And he did say that there are things that are told to me that I don't tell to you, meaning the defense counsel.
All right, I'm afraid your time is up, Mr. Krusky. Thank you.
Went fast. Thank you, Your Honor.
When you're having fun. Ms. Sweeney.
Good morning. May it please the court, Elizabeth Sweeney for the Commonwealth. Turning to the first issue, viewing the evidence in the light most favorable to the Commonwealth. The evidence was sufficient to establish the defendant's guilt for first-degree murder under extreme atrocity and cruelty and deliberate premeditation. Circumstantial evidence is sufficient to establish the defendant's guilt. In this case, we have motive, opportunity, flight, admission, and cell phone evidence. The court heard that the defendant was with the victim and his girlfriend at their house on February 24th, and Rose, the girlfriend, heard an argument or a heated discussion between the two about how the victim's car wasn't on the road because it wasn't registered. The victim was employed as a drug dealer and worked with the defendant, sold drugs on Cape Cod. And this discussion went along the lines of, I want to slap your face, that's what I mean, and the victim was apologizing profusely to the defendant for the issue with the car not being registered. The girlfriend left at 9:30, and the defendant's
9:30 or 9?
around 9:30 or 9, there's inconsistent testimony on the exact time. She left, and at that time, the defendant's very distinctive car was still in the lot. The defendant and the
Right,
victim...
I'm going to stop. Did she say when she left that the defendant was still with the victim?
Yes, the only people in the condo were the defendant and the victim, and they were seated in the living room on these two chairs. And that's very important because when the victim was found deceased later that evening, the chair that he was sitting in was tipped over, and the victim was tipped over with the chair on his back, and the defendant was sitting across from him. And when the medical examiner examined the body and the forensic evidence was looked at, the gunshots were from the same plane. So it's as though they were sitting across from each other, the shots to the torso. The shot to the head was as though somebody was standing over the victim because the blood spatter was on the table that was sort of behind the victim's head. So the shots were from the same plane, as if these two people were sitting in the chairs the same way when the girlfriend left, and the victim was in the same chair that he was sitting in when the girlfriend left that evening. And she returns home and found him in that position. The defendant made statements to his girlfriend that next morning saying, I was home at 8 p.m. last night, and she testified that that was not the truth. He told her to say that to the police and to tell people that he was home at 8. When he was home later that evening, she said around 11:30, 12:30. The CSLI corroborates the defendant leaving the Cape and heading down towards Fall River, where the pings were in...
Well, I'm sorry. Is it more accurate to say that if he had left at 10:15, he would have been in or around Mattapoisett at 11:29?
Yes.
But you don't have any CSLI between 10:15 and 11:29?
No, the first CSLI ping that they had was at 11:29 Mattapoisett. The last one was 1:40, 1:41 in New Bedford, Fall River area.
These are not like we have it now, but these are calls that were made that bounce off
Yes, the
towers. It's not-
CSLI.
it's not- But back then, it was just calls.
Back then in 2000, it was just every time you make a call or receive a call, it would hit the tower. Now we have every 3 to 5 seconds a phone is pinging to a tower.
And was there an application under 2703?
I don't believe that there was a warrant. I believe that in 2000, they did an administrative subpoena. And I'm not sure. I also believe that in the grand jury that they discussed the application for the cell phone CSLI, but that issue was not raised in the defendant's brief regarding a search warrant under Augustine or an ineffective.
Well, clearly, I mean, it would have been astonishing to have a search warrant back in 2000.
It would have. I think that's a recent.
But 2703 was in effect in 2000? I should know.
2703 became in effect in the late 1980s, the
Okay, so
SCA.
there was still an obligation to seek an application under section 2703.
De-order, yes.
Okay, and do we know whether that was done?
I believe it was an administrative subpoena under Massachusetts.
It was a Commonwealth versus Vinnie type administrative subpoena.
Yes, exactly. And the court heard earlier that the defendant was in an argument a month after the homicide with an inmate at the House Correction, where he made a statement along the lines of, the other inmate said, "You can't hurt me, you can't shoot me, you don't have a gun." And he said, "Well, that's what the other guy thought." 2 individuals testified to that. So again, we have motive, opportunity, flight, admission, and cell phone evidence. The defense attorney discusses 2 cases from 1987, Commonwealth v. Salem and Commonwealth v. Mazza. In Salem, the court reversed that case because they couldn't pin the case on the defendant where there was 2 people sitting at a table during that homicide. And in Mazza, the court said there was no access to firearms, they couldn't have a time of death, and also they couldn't put the defendant at the scene. Here we have access to firearms where the defendant was observed with a revolver, which is the type of gun that was used to kill the victim about 2 or 3 weeks prior. There was a time of death, and also the defendant was at the scene. He was seen with the victim about a half an hour before the homicide.
If I can move you to Mr. Ferguson, the third-party culprit.
Yes.
On February 24th, on the evening of the killing, Miss Simano goes to bed. I couldn't be entirely sure, but she's in bed watching TV?
She's in bed watching TV.
And then she's the one who says, "I basically was watching TV until midnight."
Yes.
And where did she say that Ferguson was there?
She testified that Ferguson was there with her that evening, and we also had a friend of hers testified that she called her twice that evening, and she heard Ferguson in the background, heard a man's voice, and believed that it was Ferguson that evening.
So she said that Ferguson was in bed with her?
Yes, that evening.
Okay, and then the other calls were at 8 and 11?
Yes.
From McGinnis.
And that issue, that was placed before the jury, third-party culprit, and the defense attorney made a strong argument that Mr. Ferguson was not there, so that issue was completely vetted regarding third-party culprit.
And I gather the Huntsman Motor Lodge is quite close to the location of the killing?
I believe so, yes. It's in Dennisport, off of 28 in that same area. Turning to the juror issue on Juror 27, the defendant asserts that his public trial right was violated. Just to clarify, the entire transcript of the juror and the judge when they were in the courtroom, that is in the transcript for the trial. That was placed in the transcript and then read back verbatim to the parties.
You have the problematic statement that Mr. Krosky highlights where the judge said, "Well, I don't bring all these things to your attention."
So that statement,
I know it wasn't at that time, but it was during the trial. He says, I'm not going to bother you with everything I hear about the jurors.
Well, he said something along the lines of, and I'm paraphrasing, I don't bother everybody with everything that I heard, but I felt this was something important to bring to your attention. The defendant makes no claim as to what those statements or what could have not been brought to his attention, but this issue he did, and rightfully so, brought it to the prosecutor and defense attorney's attention that the statements.
I think the concern is more the suggestion that he's not telling other things that might be happening.
If it's regarding Juror 27, the entire transcript, it was recorded, the juror and the judge in the courtroom. So the defense attorney and the prosecutor, they had all that information regarding Juror 27, and that was brought to their attention. It's completely in the record for the court. It begins on volume 320.
Your suggestion is when he says, "I don't tell you everything," he could be referring to all the various moving parts of a trial that go haywire versus jurors? Are we to infer that, or?
I think that that would make a fair inference regarding what he's discussing, not specifically every time a juror comes to him with a concern.
And we'll get the language, but he doesn't say, I don't tell you everything about the jurors, right?
Right, no, he's not saying I don't tell you everything when a juror comes to me with a question. He's saying I don't tell you, everything in this, complex murder case where there's an issue that comes to me that's minute. But he's saying this is something that I felt as though I should bring to your attention because a juror came to me. That's how I interpret it, that a juror concern was what he was going to tell the defense attorney in the Commonwealth, not necessarily some minor issue about, say, transportation or scheduling witnesses or something along those lines. Turning to waiver issue, the Commonwealth asserts that the defendant did not make a request to be present and under Dyer. If there's no objection, that issue is waived. He acquiesced to the procedure. He made no objection, and then there's no issue. He is now challenging what he assented to at the trial.
On the failure to inquire of the other jurors, the defense attorney does characterize it as poison, right?
He characterizes her statement later after that as
As
this
poison.
could poison the other jurors.
Right, so he says, let's have a voir dire.
Yes.
So that issue is preserved and it was squarely in front of the judge.
Yes. However, it's within the judge's discretion if there's a serious question of possible prejudice, and I suggest that the statement that the juror made about, I told an individual that her tattoo meant mouth, and we discussed in general education, doesn't rise to the level of a serious question of possible prejudice. That comparing it to cases that I cite, such as Francis Robichaud, there's no discussion about the facts of the case. It's a discussion about education in general, educational opportunities, and a small tattoo on a neck, that means mouth. And if the judge did give a strong instruction to the jury after the juror was let go, and then he appointed a foreperson, so that sort of contained any sort of issue that they may have seen with that juror leaving.
What was the strong instruction?
He said to, do not discuss the case, keep your focus on the case and the evidence.
Is it just unfortunate he said it's not essential?
I'm sorry?
He said it's not essential.
He said it's not, right.
Is that just unfortunate? What do we make of that?
I think that he was trying to soften the blow of the fact that in the middle of a trial on day 3, before deliberations, that a juror was being excused. They're down to 12 then, so they can't afford to have this issue happen again. And if they were to as the defense counsel stated, do an individual voir dire of everybody, you might have other people that think that they could jump ship, as they phrased it.
Isn't the problem, though, that without the defense attorney in the lobby during the discussion, even if the entire discussion was reported, that the defense attorney can't react to what's being said to sort of try and push as to whether or not extraneous information may have seeped into the rest of the jury?
So, in answering your question, the judge did talk with the juror, then came back and read the transcript and what happened. Then the defense attorney said more information about, can you ask her about this tattoo and what she means in education in general? And then the judge went back in there and asked those questions. So it was almost in a sense as though he did have that opportunity to talk with the juror through the judge. He wasn't there, obviously, but he did have the judge ask some more questions of the juror to fish out where or who this information was discussed with in the depth of the information. So that's on the record as far as her statement about the tattoo and her educational issues with witnesses.
Did the defense attorney after that indicate that he was satisfied with the inquiry, or was he given that opportunity?
I believe that he was satisfied. The judge didn't say, do you have anything else you want me to ask? He didn't ask any more questions. The the district attorney said, I've heard enough, and the defense attorney said, well, I want to keep her. So you can interpret his statement as, I want to keep her, as some sort of a satisfaction with, I have enough information here to make my decision, but there was no, I'm done with this inquiry.
So what do we make of a defense attorney who says, I'll keep that juror, but I want you to voir dire the other jurors because she might have poisoned them? So she's spewing poison, but she's not herself poisoned? I'm trying to figure that out.
Well, her statement that she made, I don't think you can even characterize as poison, or as that term that was used. Again, comparing it to cases, say, for example, where a juror said a defendant was looking at her inappropriately or scaring her, the statement of, I just saw a neck tattoo that looked like, that means mouth, or I was concerned about education in general, doesn't rise to that level of characterizing it as poison.
I think it's a little harsher than just educational opportunities, and I think as Mr. Krosky characterized it, it was basically a pox on everybody. They have these opportunities and they're not taking advantage of them.
She said something along the lines of, they have these educational opportunities and I'm a teacher and I'm stuck teaching these kids. But she didn't say that that statement was told to other jurors. She said we had a discussion about education in general, being teachers, and just society in general sitting in this trial, not that they were discussing people having children and being stuck teaching them, as she...
Isn't that a fair inference, though? That, I mean, they're talking about education in the context of what's going on in the trial.
I would say not necessarily comparing it to her statement to the judge where she said, we talked about education in general. That was her phrase. She didn't opine on that. And she made that statement to the judge. She said, this is my prejudice. This is my concern.
As Justice Bud said, it's obviously prompted by her feelings about all these ne'er-do-wells in her view that come in the courtroom, right?
Right.
That's why they're saying it.
I think we're making a leap to something that she didn't say. She told the judge it was education in general. And I don't think that you can characterize that as, I told the other jurors about she claimed that she was completely biased. You can't make that statement and associate it with the education in general statement.
But that's why it would have been a good idea to have a voir dire of the other jurors to find out, right?
But I don't think that that's necessarily damning to the case where it's within the judge's discretion for a serious question of prejudice. They're down to 12 jurors, and if you do a voir dire, you're going to necessarily cause concern where there was none.
Do we ever decide whether there's extraneous information based upon whether the trial's going to be blown up? Because, the judge makes a point about how many jurors they have.
Right.
And you've argued to us, well, they were down to just 12, so we have to be careful. But I don't think any of our case law says when you've got 16 jurors, you do an inquiry. When you only got 12, you better be careful.
No, you're right. I'm not trying to suggest that. I'm just saying, as the judge noted, there's 12 jurors, and under Commonwealth v. Francis, if he was to conduct a voir dire, you could cause concern where there was none, and you're leaving it with her statement where she told...
But that's true no matter how many jurors you have.
Right, right.
So...
And I'm just saying that if he was to conduct a voir dire, you could cause concern with these jurors where she just said something about education and with two other individuals that doesn't rise to the level of a serious question of possible prejudice. It was a general statement about education and educational opportunities on day 3 of the trial. There was no indication that she shared any of the information about her being bigoted and extremely prejudiced with those other individuals.
What about Juror 15's concern about her son being in custody?
So Juror 15 was concerned that her son was in custody and Ryan Ferguson, who was also in custody, could get to her son. There was no request for voir dire. The judge spoke with the defense attorney in the Commonwealth and said, well, just tell her that, the juror's information is anonymous and we can make arrangements for her son to, we'll tell the House Correction that he's there and that this issue arose. The defense counsel even said, well, just even tell her that I don't even know her name. So he almost, in a sense, acquiesced to that issue. That doesn't require, again, an individual voir dire for the same reason Juror 27 doesn't require an individual voir dire of all the jurors, because it doesn't rise to the level of a serious issue of possible prejudice. It's the issue was addressed. She didn't come back and say, I have this I'm concerned, I'm worried about my son and Ryan Ferguson, and it was left alone on, I believe, the end of day 3 of the trial. And there was no statement by defense counsel to opine on that or to have an individual voir dire. He said, just tell her, I don't even know who she is. So you can get a sense of acquiescence to the procedure from that statement. If there are no further questions, I rest on my brief.
Okay, thank you.
Thank you.